Recording in progress.
Hearings for the rental program for the city of Daytona Beach. There will be a couple minor changes to the agenda today. The first being that we are going to move up MB Miscellaneous Business 2 to be heard at the beginning of this hearing, which will then be followed by the second item, which would be Miscellaneous Business 1.
No, then we go into lien review 1, I believe.
Oh, lien review 1, yes, okay. And in the case that follows, which is BMS Holdings, Ms. Kirk, who is the inspector, will be delayed in getting here, so we'll move this to later in the agenda when she arrives.
Correct.
Okay. My name is Robert Riggio. I am the special magistrate who will be hearing these matters this morning. And our procedure for hearing these items is fairly simple. When your matter is called, if you are the respondent, if you will come up to the lectern, which would be on your right, at which time please provide the board clerk with your name so you can be sworn in. And if you are not the respondent but appearing on behalf of the respondent, please state what the capacity is. If you are mother, father, brother, sister, a property manager, attorney, so that we know that you are able to speak on this person's behalf. The code inspector will be at the other lectern, which is to your left. And once you have been sworn in, the code inspector will be providing the details of the matter and the reason that you are here. And there will be overhead, there will be pictures, if necessary, of the particular items giving rise to the matter. And once the code inspector is finished presenting the city's side of the matter, then you will be able to respond, and you'll have as much time as you need to state whatever you wish to say, whether it's a defense, whether you have compelling reasons why something happened. And there will be sort of a back and forth that can take place. And then once the arguments are finished, then I will consider what is the best outcome in the situation, who has presented whether the city has met their burden of presenting the facts that are necessary to establish that there has been a violation, or if, with respect to the other matters, the type of relief that they are seeking, or whether you as the respondent have prevailed. And it's very simple, and once you see couple people do it, you'll figure it out fairly quickly. It's not intended to be, put you at a disadvantage. Okay. Having said that, do we have any announcements?
No, sir.
Okay. Therefore, we move to the next item on the agenda. I have already approved the October 22, 2024 meeting minutes and provided them to the clerk. And now we move to the hearing of cases. And at this time, if we have any inspectors here, you need to be sworn in so that you can give testimony today.
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Thank you.
All right. Our first order of business is miscellaneous business 2, CEB 031218, 407 Jefferson Street, J.H. and Mary J. Dickerson. This is a request to release the property at 537 South Martin Luther King from the encumbrance of this lien. And it's my understanding the city may be purchasing this property. So if someone could come forward on behalf of the city and the respondent, if there's someone here on behalf of the respondent, and present why it is that this matter is before me.
Could you state your name, please?
Either one of them, you're fine.
Doesn't matter.
Good morning. My name is Michelle Tolliver. I'm the project manager for the Midtown redevelopment area. I work here at the City of Daytona.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
If you could present your presentation.
So what I am here to share with you, Mr. Riggio, is that I have a site map, if I could get this to you.
Okay.
And what the map shows that Mr. Riggio has is parcels outlined in brown. And there is a vacant parcel that is not highlighted at all. And that is the vacant lot that the city is under a contract to purchase, but it's attached to the Jefferson Street case. And
Okay.
in order for us to close on that lot, we need to do it or request for a partial release.
All right. If this could be labeled as Exhibit 1.
And just for the record, the properties that Mr. Riggio was provided with, the ones that are brown, the city closed on those back in June of 2024. And the tentative plan for that property is to build mixed use and mixed income housing. We want retail and residential on that property for the community.
Okay. And is there currently, you said there's a lien on the property?
Yes, it's encumbered under the 407 Jefferson Street case.
Okay,
So it's cross encumbered, Mr. Riggio. Anthony Jackson, attorney for the city.
okay.
And there's actually 2 liens, but it's the same case.
2 liens, okay. And it appears that one lien was partially paid. Am I correct that there was an amount of $9,000 that had been paid at some point?
Yes.
No,
no,
that's
that's-
MMB1, I believe.
No, that's
I mean, MB1.
Oh, okay, I'm sorry.
Not MMB.
I'm looking at the wrong one. That's another lien review.
That's another lien review.
Okay.
Did you have a copy of MB2?
I have,
It's behind your addendum that I gave you this morning.
oh, okay. I haven't. Okay. I haven't seen these before, so I'd just like to just skim through it real quick. All right. And the respondent has no objection to the lien being removed from this property, I assume?
I would expect.
Just
Okay.
for the record, I spoke with the property owner on December 28th, and they have no objection to this partial release.
Okay. I just noticed, just skimming through this contract, that all of this is contingent upon city commission approval.
Yes, certainly. Are you at the point, or has that already been approved?
For the purchase of the property,
Yes.
the commission has already approved the purchase.
Okay.
So that's already been
So there's no outstanding entities that need to make any decisions regarding this. This is like sort of the last piece of the puzzle.
That appears to be right. and
Yes, that's the way I
just confirm.
understand it, and that was my communication with the title company.
Okay. All right.
And as you can see, Mr. Riggio, there are two orders imposing fine lien. One recorded 4/8/2012 on the case number CEB 03-12-18. The other one, same case number, recorded, that appears to be June 1st, 2012. Is that correct? And so we'd need to do a partial release as to those liens so that this property can be, the property that we're seeking can be free and clear of those liens. We don't want to totally release those liens. We just want a partial release as to their effect on what's our address here? 537 South MLK.
Okay. And I assume that it's sort of a wash anyway. The owner would probably just increase the purchase price to cover the lien, so it would have just washed itself out one way or the other.
Yeah, it's more administrative cleaning.
It is, yes.
And it's clears it up much simpler
Yes, sir.
and probably to the city's benefit.
Yes, sir.
Okay. I have no objection to that. Is there anything further you want to add?
No, nothing further.
Okay. Now, the lien is in the name of J.H. and Mary J. Dickerson on this property. That would be
Correct.
okay. So, therefore, having heard the arguments in this matter, in case number CEB 03-12-18, property being at 407 Jefferson Street, I hereby order the lien in case number CEB 03-12-18 to be reduced to the amount of $0. Isn't that
As it relates specifically to 537,
right? Isn't that are there other liens
there's
associated with?
two liens under the same case number, so it would be the two liens under that case number, and
Okay.
they would be asking for them to be zeroed or released only as to 537 South MLK.
Okay. All right. So if the property owner has property elsewhere, these liens would attach to that.
That
or
would remain yes.
attached to it.
In addition to the principal.
Okay.
Right.
Therefore, in case number CEB 03-12-18, property being at 407 Jefferson Street and owned by J.H. and Mary J. Dickerson, I hereby order the liens in that case number as they attach to the 407 Jefferson Street property only.
No, sir. You're releasing the 537 South Martin Luther King from
Oh.
the encumbrance of 407 Jefferson Street. if
Okay,
that's
so
your-
the respondent actually is at another address
Well,
and owns the
the
property at
violations
530.
were at 407 Jefferson Street, so that's where the lien was imposed. But it's encumbering by name.
Oh, this is
onto-
additional property owned by the respondent.
Correct.
Okay.
Correct. So the liens will remain on 407 Jefferson. We're asking to release
Just
537 South
537.
Martin Luther King.
Okay, now it's clear. Therefore, and let's start over again on this. Case number CEB 03-12-18, I hereby order the lien as it that attaches to the property at 537 South Martin Street, or South Martin Luther King Street, to be reduced to 0 as it pertains only to that property.
Okay, and that will be South Martin Luther King.
And released.
Dr. Martin Luther King Boulevard.
And remain in effect as it relates to all other properties owned by the respondent, including that one at 407 Jefferson
Correct.
Street.
Yeah, only just one clarification. That's only to the address. It's 537 South Dr. Martin Luther King Boulevard.
Yes, 537 South Martin Luther King Boulevard.
Okay.
Okay.
I think that covers it.
Is that clear?
Rizzo.
The
Yes.
lien is reduced only, or it's reduced to 0 only for the property at 537 South Martin Luther King Boulevard.
And you say
And
lien singular, but you mean lien plurals, since there's two liens as
Yes,
related
the
to
liens
that are
in that,
associated,
in that case,
that are
right?
cross-encumbering from that case.
CEB 03-1218, there are several liens from
There's
that
two.
case.
Yes,
matter.
sir.
Correct.
Yes.
Okay, thank you. I think that covered it.
That's good.
Okay.
If you're happy, if you want me to rephrase it.
No, I think Ms. Barnes got it.
On
and
some
I
of
think you
these,
said
it's sometimes easier if I have a pre-prepared suggested order so that I'm not, because this is kind of like the first time I've seen this and I didn't deal with these matters previously, so I'm,
Yeah, I may get in trouble because I think my paralegal may have prepared one, but we're good.
okay. If you're fine, then I'm happy.
All right, thank you, sir.
All right. It takes care of that one. All right. Our second lien or miscellaneous business, this is actually, I believe, a lien review, is going to be CEB 03-1058, 865 Winchester Street, David Mayhew. And the new owner is Gail Smith, the GLS Revocable Trust. There's currently a lien on the property in the amount of $10,000, or well, actually the total amount is $18,517.84, including the lien, interest, and recording fee. Okay.
My name is Gail Smith.
My name is Diane Woods.
All right.
Or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay.
Aye.
Ladies, this is your request, so you are essentially the petitioner in these matters. Have you resolved this, Mr. Stenson?
Yes, sir, we have.
Okay, Mr. Stenson, if you could provide, Mr. Stenson, your code enforcement officer?
Yes, sir, John Stinson, Code Inspector with the City. My
Okay, and
qualifications are on file.
if you could give me a brief review of what has transpired?
Yes, this case is from 2009. The former owner had multiple violations on the property. Right now, Ms. White is the new owner. I'm sorry, Ms. Smith is the new owner. I was at the property, performed a reinspection of the property on 13 January 2025. There were no violations to be noted on the property at all. We met with the department manager. We've come to an agreement as a reduction of the lien to accept $2,000.
Okay. So this property's been brought into compliance?
Yes, sir, full
Okay.
compliance.
And some payment has been made toward the lien? You said there's 2,000, or are you just reducing?
We are reducing the lien.
Okay.
We're recommending that it be reduced to 2,000.
Okay. Ms. Smith, you understand that there will be a $2,000 lien that will remain on this property
Yes, sir.
that will, that will continue to accrue interest and things of that nature. So
We're
when,
asking that it be paid within 30 days?
That's correct.
our
Paid in
standard
30 days.
request.
okay. I'm sorry, it's been a while since I've done these.
I know, it's been several months.
And so you will have 30 days in which to come up with the money to pay that off. Otherwise, it reverts back to the original amount. So there's an advantage in trying to come up with that money, and because it's a reduction of 16,000 some odd dollars. Okay. So therefore, in case CEB, do you have anything further to say?
No, sir.
Okay. Case CEB 031058, property being at 865 Winchester Street. Previous owner being David Mayhew, the owner is Gail Smith. And what is the relationship of the DLS Revocable Trust?
That's my account that I had put it in.
Okay, okay. And so the actual owner now is the GLS Revocable Trust?
Yes. I'm the
Okay.
owner of that account.
Okay. New owner is Gail Smith, who is part of the GLS Revocable Trust?
Yes.
Would that be correct?
Yes.
Okay. In that case, I order the lien to be reduced to $2,000, subject to being paid within 30 days, or the fine will revert back to the original amount, which at this time was $18,517.84. And I always add to this that if you run into any problems making the payment, please contact city attorney's office.
Okay.
And inform them that you have a problem, and sometimes they can work something out, sometimes they can't. So, but at least you have a shot, because once the 30 days elapses, it goes back to being the original amount.
Okay.
All right?
Thank you.
Mm-hmm.
Thank you.
All right. All right, the next case, we are now moving into the new cases. The next case, number one, the inspector is currently not available, so I'd like to put that one on hold. For now, we'll just move it to the end of the agenda.
Yes, sir.
And then we'll get back to that when the inspector is present. So we will move to the new cases of irreparable and irreversible. First case being number 2, RTL 012501, Kachahi Owen Trust and Kachahi Vanessa Trust, cited for failure to correct violations of Land Development Code, Article 4, Section 4.1.A, Article 5, Section 5.2.A.2 at 113 Grand Berwick Court. Sir, if you could state your name and be sworn in by the clerk.
Owen Kajaji.
I'm sorry.
Owen Kajaji.
Do you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay. Mr. Yates.
The case before you is a zoning violation. This case was field generated. Property is zoned PDG. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed November 19th, 2024, and they were notified the same day. The property stopped actively advertising as of November 21st, 2024. The daily posted rate was $155, and it displayed 22 reviews. The check-in, check-out time shows 4 p.m. and 10 a.m. These actions, these actions are irreparable and irreversible in nature and due to the actions of the property owner. City is requesting a one-time fine of $1,000.
Okay. Is it Mr.
Yes.
Jackson?
Ms. Magistrate, and as I'm doing these proceedings, I would speak to the respondent as well as everyone else that's present that would be that will have a short-term rental violation case before you today. I ask you to listen up because what I will be presenting to the magistrate is the city's position on why these cases should be deemed irreparable and irreversible in nature as provided by the statute, Chapter 162.09 1D. So the reason they should be deemed irreparable or irreversible in nature is that, first of all, there's a beneficial gain to the property owner who is advertising conduct that is prohibited by the city's code. The effects of renting property or holding out property as vacation rental cannot be reversed and it cannot be repaired. Property is advertised worldwide, marketing a destination that draws people from all over the world for principal special events such as our current Daytona 500 races and Bike Week, Biketoberfest, and throughout our spring break and summer months to our world's most famous beach. The properties may also be marketed as a draw to nearby destinations such as Disney World and Space Coast. And once the properties are advertised, they're never truly unadvertised. The reality of the World Wide Web is that you cannot push such advertisements back into the tube. Information posted today can be printed and saved, forwarded, retweeted, and even copied and posted on other sites. And that limits the city to the only solution for the advertisement is to require that all postings be removed. The information has long-range effects in luring patrons under contract to participate in unlawful stays in our city. The patrons risk poor health, poor safety and welfare due to unregulated or self-regulated vacation accommodations that patrons enter into at their own risk. One single day of advertising can potentially book a property for the whole year. These promised stays are potentially to the detriment of the patron and definitely to the detriment of licensed hotels, motels, and lawful vacation rentals that have gone through proper zoning regulations. They've gone through proper inspections and proper licensing, proper insurance, and proper taxation required by law. The transit nature of the rentals limit the means of the enforcement typically limiting it to identifying these properties by their advertisements. By the time a code enforcement officer goes to the properties, the transients typically are gone from the property, or they claim some misleading relationships that are often contradicted by the advertised visitors' comments. The monetary effect of these unlawful rentals is that it's avoidance of local taxes, adequate insurance coverage, unfair business competition against lawful accommodations business, and lawful vacation rentals. The community effect is that the transient business use within unauthorized residential neighborhoods affect density, parking, noise, and safety. They affect the peaceful enjoyment expected in residential neighborhoods, and they diverge from traditional and reliable residential norms. Our city commission received a demand from the business community that led to them making a request of the city staff for a strong deterrent to those that are raking in the profits and avoiding the local tax, avoiding zoning requirements and the regulatory controls. We have all seen rentals going for amounts as much as $7,000 a week and realize substantial fines is the only deterrent tool available. By the time we arrive and say stop, the beneficial gains already realized. They are adopted by the city defines vacation rentals to include advertising for transient guests. Therefore, the city requests a finding that these violations are irreparable or irreversible in nature. Now, when we talk about the effects, the case law the statute provides that for a city of our size, that when we look at the fines, the maximum fine for these types of violations will be a $15,000 fine. And then we initially felt that that was warranted in all cases because of the necessity for deterrent and the gains that were potential for people who were doing short-term rentals. And for quite some time, the general request of the city was for a $15,000 fine. Over time, after with the magistrate's suggestion, instruction, and rulings, we realized that there were circumstances where you, Mr. Magistrate, believed that there were it was reasonable that if someone responded quickly, that a lesser fine of $1,000 would be appropriate. And so, in most cases, when someone responds quickly, the fine has been a $1,000 fine, and that's our request, that we recognize in this case that the respondent responded quickly, and we're requesting that a fine of $1,000 be imposed. Is that correct, Inspector? Yes, sir. And I don't have anything further. I didn't mention to everyone listening that what I'm saying is our position. Anyone who wants to speak to the magistrate regarding that, I think he will share that as well. Anything that I've said can be spoken about or challenged if it's so elected. I have nothing further.
Okay. Anything further, Mr. Yates?
No, sir.
Okay. Is it Mr. Owen?
Yes.
This is your turn now to respond.
So we did comply, like they said. We took it out. I was just, I'm here to ask to just the fee be reduced to 0. And for the reason that we were unaware that we won't be able to accommodate their home for more than 30 days. So we thought we were under our HOA handbook, which states that we can't rent for less than 30 days. And we did rent for more than 30 days during our history. And I could give you the copy if you need to. After that, we did try to apply for the license, but they say it's been ceased to enforcement. It's no longer being done by the city.
Mr. Owen, what did you seem to have I believe, a piece of paper?
So the HO handbook. So we had rented we use the property for personal use. It's not for business, but when the days that we're not there, we rent it for people who are in this for more than 30 days, not less than 30 days.
Okay.
If I can have clarification, is he saying the HOA handbook? Is that what
Mr. Jackson, I think you should take.
Yes, he's saying this is the HOA handbook and that the HOA allows it.
Okay.
But
The handbook,
do the right
as
thing.
I
Yeah, we
read
didn't know.
it says that any rental less than 30 days.
Yes. Yeah.
Okay, it doesn't say, in my opinion, that rentals are allowed. It just says that if for some reason there is one that is allowable, then it would be okay under those provisions. But you're still on notice of what city code is.
Yes.
And these types of situations are part of why I've been hearing these now for about 5 years. I, in certain cases, reduce the amount of the fine to deal with those types of things where we had, but that still doesn't mean that you don't have a duty to find out that what you're doing is allowed by city code. You are on notice of that, and I think there's some old Supreme Court cases that go back a long time that say whether you sat down and read the code or even aware of it, you are on notice of it. And this is one of those circumstances where you have been renting now, and if I understand, there's been, Mr. Yates, you said this rentals have been going on for some time.
Yes, there were 22 reviews.
Okay. So, I mean, you have generated a fair amount of income based on something that you are not allowed to do in the city. And so I still feel that a $1,000 fine is appropriate under the circumstances.
And Mr. Magistrate, just for the benefit of the respondent and anyone else listening, the HOA rules don't trump the city rules, right? But in this case, any short-term rentals of less than 30 days are prohibited, which first acknowledges that it's short-term rental, but it gives a limit that you can't go less than 30 days. So you can't do a 10-day short-term rental. If indeed, as the magistrate had pointed out, would be as the magistrate had pointed out, would start with an issue of, excuse me, would start with the question of are you doing short-term rentals at all? And the answer is, in our code, unless you're zoned for that, you're not allowed to do it. Yeah. But if indeed you had a place within your HOA where you were allowed, then they're just telling you can't do it less than 30 days. So that doesn't eliminate, that doesn't change doesn't really change any rules. It's still a short-term rental.
Well, it implies that short-term rentals longer than 30 days, which are we're starting to get a longer-term rental, and not the bed and breakfast, vacation rental type things.
Yeah, they don't want a weekend stay, but they'll allow a 30-day stay, but it's still a short-term rental.
Right, and sir, please understand that under city code, to rent a property, it has to be, and correct if I'm wrong, Mr. Yates, 6 months and a day,
Yes, sir.
and you have to obtain the proper license or business license from the city.
Right, you need a business tax receipt. We have a registration program that I'm sure the inspectors or the division would inform you of.
Yeah.
Okay. Mr. Owen, do you have a problem if this is entered into as Exhibit A in this proceeding?
Yeah. No, I think...
You have copies of this document, or you can get another copy of it for yourself?
Yeah, I could get it.
Okay, so let's just, since we're talking about a document, I'd like to have it placed in the record as Exhibit A. Okay. So, Mr. Owen, do you have anything further to say?
Yeah, I mean, again, I did talk to him prior. I was just trying to see if there was an option of getting a reduced rate. That was my main goal, and we complied, like he said.
You are getting the benefit. When this program initially started, the city was asking routinely for the maximum for everyone. And I have seen that there are instances such as yours where especially where you comply immediately or in a very short time period. And as Mr. Jackson said, there is that's kind of ambiguous language in that HOA. It's prohibited, but they've got to be longer than 30 days.
Yes.
But it doesn't say that they are allowed. They're only allowed in the HOA if they're longer than 30 days, but city code, as Mr. Jackson has pointed out, trumps your HOA rules. So having heard this, this matter, therefore, in case number 2, RTL 01-2501, I find the respondents, is it Kachahi?
Yes, Kachachi.
Kachachi, Owen, is a trustee?
Yes.
And Kachachi, Vanessa TR, cited for failure to correct violations of Land Development Code Article 4, Section 4.1A, and Article 5, Section 5.2.A.2. Of the City Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D, Florida statutes for the property at 113 Grand Berwick Court, and hereby order that respondent shall pay a fine in the amount of $1,000 and not violate again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each of Florida statutes.
You also have a compliance date.
Yes, the compliance date is November 21st, 2024.
A fine of $1,000. As I said, it had been as much as up to $15,000, and that's what it had been some years ago. You're bringing your property into compliance quickly.
Thank you.
Thank you.
They'll send you the details in the mail about payment and everything.
Oh, okay. Thank you.
Okay, we move on to case number 3, RTLO 12502, Ola Enterprise UT LLC, Development Code Article 4, Section 4.1A, Article 5, Section 5.2.8.2 at 126 South Oleander Avenue.
Could you state your name, please? Slowly, please.
Nick Kazakov.
Is that Gascon?
Kazakov.
Kazakov?
Yes.
Okay.
Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Right. Mr. Yates?
The case before you is a zoning violation. This case was field generated. The property is zoned DB6. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed November 21st, 2024, and the property stopped actively advertising on November 22nd, 2024. The city is requesting a one-time fine of $1,000.
Okay. Mr. Jackson?
Kaskov.
You got.
And everyone else listen. As I said before, I present to the magistrate. We've elected that to make this procedural, that we will present this in every case.
Yes, sir.
However, we allow you, if you so elect, you can waive me presenting what I've previously presented, if you've heard it. And if you want to waive me presenting that again, what I'd be asking the magistrate to do is just to place, I don't know what term I want here.
Incorporate.
That's what I'm looking for.
Yeah, I was listening carefully, yes.
Okay, so I would ask the magistrate, based on your response, to incorporate what I said previously into this case, if
Indeed.
that's okay.
Yes.
Okay.
Okay. Therefore, based on the statements of the property owner, Mr. Kazakov, I incorporate Mr. Jackson's previous comments in the earlier matter, case number 2, to be relating to irreparable and irreversible, to be incorporated into the record. And I'd also tell Mr. Kazakov that if he objects to anything that that Mr. Jackson stated, you can voice your objections. All I've done is placed his statements in the record. That's all.
Understood.
Do you have anything you would like to say?
No. I spoke to Inspector Yates, and then we removed the property on the following date. We understood the violation. I was under the impression that, and I was reading that under the Florida law, Florida allows 30 days plus rentals, but as per city code, we are not allowed to do that. So I understand that, and we complied to that order.
Okay. Therefore, do you have anything further to add?
No, sir.
Okay. Therefore, in case number 3, RTL 012502, I find the respondent, Ola Enterprise UT LLC, to have been in noncompliance of Article 4, Section 4.1.A, and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals. Such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 126 South Oleander Avenue. And it will subsequently come into compliance on
November 22nd, 2024.
November 22nd, 2024. And hereby order the respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again. And if for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Thank you.
Thank you.
Case number 4, RTL 012503, Tibor and Ladiko Benke, cited for failure to correct violations of Land Development Code, Article 4, Section 4.1.a, Article 5, Section 5.2.8.2, at 145 Boysenberry Lane.
Could you state your names, please?
Tibor Benke.
And are you also testifying?
My name is Ildiko Benke.
Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Mr. Yates?
The case before you is a zoning violation. This case was field generated. The property is zoned PDG. Other accommodations than short-term rentals are not permitted in the zoning district. The violation was first observed December 6, 2024, and they were notified the same day. The property stopped actively advertising as of December 12, 2024. The daily posted rate was $315, and the advertisement displayed 4 reviews. The check-in, check-out time were shown as 3 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Mr. Jackson?
Mr. Benke, Anthony Jackson, attorney for the city. What I've explained previously before, I've presented a position of the city to the magistrate. I can present that again if you so desire, or you can elect to waive me presenting that again.
We waive. You totally understood what you said.
Okay, thank you.
Okay, then let the record reflect that the respondents have waived Mr. Jackson's repetition of the arguments in support of, or the city's arguments in support of this matter being irreparable and irreversible as previously set forth in case number 2 RTL 01-2501. And again, Mr. Benke and Ms. Benke, I would say that if you have any objections to anything that he said, that you can certainly state those. We're just incorporating his comments into the record.
No, let's incorporate it.
Okay. Do you have anything further that you would like to add?
Yes, I would like to say that we never intended to have a shorter rental. It was set really high price, and as I sent by email to Mr. Yates, it was a kind of safety measurement tool what we used, and I totally understand it was not correct, but at that time I didn't think of that. So for those vacation friends who we met somewhere around the world, we just wanted to have a safety measurement when we invited them to our house, and they had to use the Airbnb to identify them or prove their identity. And the money they paid, we technically spent on accommodation with them, food, drinks, whatever. So it was a kind of wash, and we did the same thing when we were visiting them in Canada or somewhere there. So it was not a Airbnb operation at all, and we didn't have any benefit, what the statute said, and we didn't cause any damage for the neighborhood.
Okay. But, Mr. Yates, this was on one of the Airbnb.
It was on Airbnb, yes. It was a standard profile on Airbnb.
Yeah, sir, I've heard other people who have used Airbnb for in this situation, but it is a commercial platform, and its intent is to facilitate rentals, and that is something that I understand what you're saying, but the city has no way of disproving that that this commercial entity that is set up to facilitate actual commercial rentals is not being used in that capacity.
The record says that it was not being used as a capacity, and as I mentioned earlier, the prices were set so high that it would never inquire any, nobody wanted to rent it because it was not intended to be rented. And that was the safety measurement only.
The problem here is also that Airbnb is a rental website, and city code also, if I understand Mr. Jackson, from previous matters that we've had, also
Prohibitive of the
makes it
advertising.
setting it out
Yeah,
for
holding it
rent.
out for, as a
Totally
rental.
understand that, and it was my bad. I didn't think of that way because we never had the intention to have an actual Airbnb. I never had the intention to rent it to strangers.
Oh, I understand, sir. I understand, but in these situations, I have treated these in the same fashion as I have treated the others, but you did come into compliance quickly, and so I take that into account. And therefore, the city is asking for $1,000.
Yes, sir.
Okay, and that's, I think, is appropriate.
We never made any money on that. The statute, so sorry, let me repeat it. The statute said that we have to have benefit and damage to the neighborhood. We never had any benefit and never caused any damage. So I don't feel like it's fair to get.
Mr.
Just for
Jackson.
clarification, I'll make reference to the statute. Those aren't statutory provisions. Those were just the position that I've taken to say that it's irreparable and irreversible in nature. The provision that you're in violation of is one that says that you can't advertise a short-term
Totally
rental, whether you
understand.
intended it to be utilized or seen that way. You can't advertise it as a short-term rental. Neither can you actually have it as a short-term rental, even if it wasn't intended to be that. That's what we see. It's what the position of the city, based on the evidence presented, is that it shows the a daily rate, even if the daily rate is ridiculous according to the respondent. It shows a daily rate. It shows a check-in, check-out time. It has all the appearances of a rental that would be available as a short-term rental property, a property that's commercially available, and it's advertised as such. And with those being the criteria, they meet the statutory criteria, and we would recommend, I think you've already made a finding that it was a violation, but we would recommend that we just treat it, and I say all the time, and I say it again, I'm not trying to make anyone a bad person. I don't think anyone intends to do this as a bad thing. We just have no way to differentiate between the totally honest and the person who just is giving us a reason that, you know, may be right to them but not right to anyone else. So our position remains the same. It's consistent with the way we would handle someone that responded once they understood what the rule was. Our belief is that in one way or another that there's still a beneficial gain, even though that's not a requirement of the law. But we believe that it is.
It's my understanding this is really at the heart of this is a zoning violation.
That's correct.
And so whether or not there's something done that is improper or whatever on the property is sort of to some extent irrelevant to it's held out as this, and that is not allowed, period, by the Land Development Code.
That's correct, sir. So at its very base, that's the correct answer, that it is a Land Development Code violation. It's punishable by up to $15,000 fine, and we agree with a consideration of a fine of only $1,000.
Okay. Mr. Benkei, I'm going to levy the $1,000 fine as we do in other matters. And so therefore, in case number 4, RTL 012503, I find the respondents Tibor and Ladiko Benkei to have been in noncompliance of Article 4, Section 4.1.a and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals. Such violations are irreparable and irreversible because the improper benefit obtained by the owner and damage surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 145 Boysenberry Lane, and will subsequently come into compliance on December 12th, 2024, and hereby order the respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, respondent may be placed on a subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. And Mr. Benkei, I would also point out something as I was reading the order that is, as I said, it's a zoning violation, and part of this is to reduce what might be considered transient ownership or use of properties. And I know in other jurisdictions, and I suspect in this city as well, in zoning areas where people live there full time, when people come in and live on a short-term basis, like, and I know I had been involved in one of these years ago, where in another city people would go to Disney and then they come back. Hey, they're just staying for 3 or 4 days. They love the fireworks at Disney at 11, and so fireworks at somebody else's house at 2 in the morning when they drive back, we're fine. And so that sort of has a detrimental effect on established residential neighborhoods where people are moving in and out constantly. And that had slipped my mind as I recall that.
It never happened.
Well, I understand, but once it becomes a transient type of use, you have no control over those people. And so that said, as I said, you've been found in violation and a fine of $1,000. Thank you. Case number 5, RTL 01-2504, Allison Kristen Miller, site for failure to correct violations of Land Development Code, Article 4, Section 4.1.a, Article 5, Section 5.2.2 at 276 Brookline Avenue.
Could you state your name, please?
My name is Susan Miller. I'm Allison's mother.
Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
And do you have permission to speak on her behalf?
Yes, I do.
Very good. Mr. Yates?
The case before you was a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in the zoning district. The violation was first observed November 15th, 2024, and they were notified the same day. The property stopped actively advertising as of November 15th, 2024. The daily posted rate was $140. The check-in, check-out times show as 4 p.m. and 10 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay. Mr. Yates, did your search of the records indicate that this property had been rented out before?
No, there were no reviews on this one yet.
No
It was
reviews.
new.
Okay. Ms. Miller?
Well,
Oh, Mr. Jackson, I'm sorry.
Ms. Miller, I think I've seen you back there, so you probably heard me make my presentation to
Yes, sir, I did.
Mr. Riggio, and is that something you need me to?
I do not need it repeated.
Okay.
I won't say I agree with it, but I don't need it repeated.
And as Mr. Riggio said, you'll be welcome to speak to any portion of that that you desire.
It would do me no good.
Okay. All right. Therefore, let the record reflect that Mr. Jackson's statements regarding or presentation relating to irreparable and irreversible as relates to these types of violations that he presented in case number 2, RTL 01-2501, be incorporated into the record of this matter. Okay. Mr. Yates, anything further?
No, sir.
Ms. Miller?
No, I have nothing to say. Christy is, we call her Christy. She's in Costa Rica. She went there hoping to rent her house out while she was gone. She's working there 6 months. It was not intended as a full-time business. Simple for her to be able to manage her finances a little bit. That's it.
Okay. And Ms. Miller, the city is asking for a $1,000 fine.
I understand. Any grace on that would be appreciated.
Okay. Mr. Yates, did your review of the documents indicate when this item went up to,
No, that's not information I can obtain.
okay.
It only allows me to know that it's new, and the exact range of that, I do not know off the top of my head what Airbnb classifies as new. I believe it's the first 3 months, though, but
Okay, so it could be anywhere from 3 months to 1 day.
I believe yes.
Okay.
Yeah, and she had had it up about 3 days, according to her.
Okay. All right. This is a little bit different, and I'm considering reducing I have to, fine, it is a violation to
Understood.
use it, but at least to give you a little bit break of reducing it to $750. Do I hear any objections from the city to that?
No, sir.
No, we respect your judgment in that. It's your discretion. The general position of the city is that we just try very hard to be consistent with the way we urge these. I understand your position or your expression that you believe this is different, and we would yield to that perspective of the magistrate.
Okay. Under the unique circumstances of this matter, and the quick turnaround time and the fact that there are no reviews, and the statements made by Ms. Miller, I'm going to reduce the amount of the fine to $750, a little bit of a reduction under
appreciated.
unique
Thank you.
circumstances. So in case number 5, RTL 012504, I find the respondent, Allison Kristen Miller, to have been in noncompliance of Article 4, Section 4.1.a and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs time the violation occurs and cannot be undone as provided for by Section 162.09 1D Florida statutes for the property at 276 Brookline Avenue, and to have subsequently come into compliance on November 15th, 2024, and hereby order that respondent shall pay a fine in the amount of $750 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for hearing before the special magistrate for consideration of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Thank you.
Thank you. Mr. Riggio, the next case is appearing via Zoom.
Okay. Next case, are they available? Okay, case number 6, RTL 012505, Michelle J. and Danielle D. Carter cited for failure to correct violations of Land Development Code Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 350 Auburn Drive.
Sir, can you hear me?
Yes, I can. Thank you.
Could you state your name, please?
My name is Michelle Carter.
Could you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, I affirm.
Thank you.
Mr. Yates.
The case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed November 22nd, 2024, and they were notified the same day. The property stopped actively advertising the same day, November 22nd, 2024. The daily posted rate was $167. The check-in, check-out time show is 4 p.m. and 10 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000. And this would be the same case as the last one, where it is a new listing and there are no reviews yet.
Okay. All right, Mr. Jackson.
Mr. Carter?
Yes, Mr.
My name is
Jackson.
Anthony. Well, I'll go to the podium. I think it's better for the camera folks. Mr. Carter, my name is Anthony Jackson. I'm the attorney for the city of Daytona Beach. I'm the deputy city attorney and handling these matters. I've previously given a presentation to the magistrate on the city's position regarding finding that these violations are irreparable or irreversible in nature. If you were on, which I know typically they would put you in a holding spot where you can hear these proceedings. If you're able to hear them, is that something you need me to repeat? First of all, one, did you hear my presentation? And two, is it something you need me to repeat?
Yes, Mr. Jackson, I heard your presentation earlier. I was online when you made the presentation.
And is that something you want me to repeat, or is that something you want to waive and proceed on?
I would like you to repeat the portion where you say that it is detrimental to the hotels and motels of the area. I'm not quite sure I understood that one correctly.
Okay, let me do this then. Why don't I repeat it in full? Or if you're asking for me to clarify that for you, I'll just clarify that portion. Is that what you're asking?
Yeah, just that portion, please.
Okay. Certainly. So as I speak to the issue of detriment, let's see, where do I say that? I said one single day of advertising can potentially book a property for the whole year. I say that these promised stays are potentially to the detriment of the patron. That's the person who is there because they don't have any the safeguards. It's unregulated, right? But also not only to the patron, but I said it indefinitely to the detriment of licensed hotels, motels, and lawful vacation rentals that have gone through proper zoning, regulation, proper inspection, proper licensing, proper insurance, and proper taxation required by law. And just expressing that in comparison, a person who hasn't gone through any of these things being weighed against a person who had to do all of these things to be able to get the necessary approvals is really the point I was making.
Okay, thank you very much for reading that. That's very clear. Thank you.
Now, as to the rest, the magistrate would need to know if that's something you would allow him to incorporate into this proceeding, what I said previously.
No, that's fine. I can waive the rest of the presentation.
Okay.
Now, Mr. Magistrate, if I may, we have been owner of this place only since September. We live in Canada and we use the house from time to time. And my real estate agent referred me to a person that is actually managing many properties for short-term rentals. So, and that person was of the view that given the number of similar properties in our neighborhood, that was okay to go ahead and do some short-term rentals. But as Mr. Yates has pointed out, we haven't done any except the few that the one that has been mentioned in November. So we've had very little revenue from short-term rentals. And as Mr. Yates has mentioned, the very day we received the notice, we immediately removed the house from the platforms and we canceled all future rentals that were booked. And that has been out of the rental platforms since ever that day. So, Mr. Magistrate, if I may, given the very little revenue we got out of it, we would ask a grace on the amount of fine that the city is requesting. Thank you, Mr. Magistrate.
Okay. Mr. Jackson? Mr. Yates? Do you have anything further to add?
No, sir.
Mr. Jackson, do you have anything? Okay. All right. First, let me take care of the business, and that is in terms of, as I understand it, and correct me if I'm wrong, Mr. Carter, you're willing to incorporate Mr. Jackson's previous statements that he gave in the earlier case, number 2 RTL 012501, relating irreparable and irreversible, but you also have your own personal feelings with respect to his comments regarding, or objections, you might say, as it pertains to what he stated relative to businesses, et cetera, within that.
No, once I heard him say it back, it's okay with me. I thought he was referring only to hotels and motels, but he did incorporate other licensed short-term rental situations, because as I was checking this morning, Mr. Magistrate, there are still over 1,000 short-term rentals available in Daytona Beach, some of which are still in my neighborhood. So I was wondering whether those 1,000 short-term rental still do some bad publicity to those hotels and motels, but I understand that some of those are licensed, but I'm pretty convinced that some of them are not licensed. But that being said, the point is,
we will know the point.
Very dramatic.
Sir?
there you go. Okay, so we're new to Daytona and we complied.
Because your connection went off.
Yeah.
thing you said was some are licensed.
Some of are licensed and some are not, because I can see they're in my neighborhood. So anyways, we removed any publicity. We didn't make much money out of it because we're new there, and we asked for the clemency of the magistrate. There you're back. So I was asking for the clemency of the magistrate.
I can't hear you. You blacked out for your internet connection went out for about a minute.
Yeah, I'm sorry about that. I couldn't see you either.
So you understand. I want to hear what you have to say, but
I'm asking for the clemency of the magistrate, given that we're new to the city and we complied immediately to the request of Mr. Yates. And we're off the platforms now, except for people that would like to rent for 6 months plus 1 day, which is allowed by the city, as I talked to a city official about it.
Okay. Mr. Yates, with respect to what Mr. Carter has said, now my understanding is that short-term rentals are allowed in certain zoning districts.
Correct.
He's in a zoning district, and your statements have been that short-term rentals are not allowed. Now, he stated that there are other short-term rentals in that area. Are they unlawful short-term rentals?
If they are in single-family residential 5, SR5, yes, sir, they are.
Okay.
And I am actively trying to find them. If you want to send me any addresses, I'm happy to investigate those addresses. It's what I do.
Okay. So I just want to get that out of the way first, and that is that, and secondly, There are places in the city, I think it's very limited, where short-term rentals are allowed.
Yes.
Okay. And do those individuals have to obtain a permit to rent their property on a short-term basis?
Just a tax receipt.
A business tax receipt.
Which would also guide them in telling them whether or not it's property zoned for what they desire to do.
Okay.
So it's going to permits and licensing.
Yeah, and if you had gone, they would issue it if you can have a short-term rental.
Okay. Now, are there provisions in that for contacting those people in the event that there is some type of issue that arises at that property?
Well,
there isn't currently a specific program. However, as part of obtaining that, you are going to give us contact information that we would use if we needed it in that case.
Okay. Because, and Mr. Carter, I'm not saying these things are going on at your property, but I do recall from past occasions, there were like during the truck weeks, there were single-family neighborhoods that were getting torn to pieces by big trucks and people drinking till 3 and 4 in the morning and things of that nature. And there was no way to contact the owners of those properties. Am I correct in that? I mean, this became a police matter.
Yes, that's correct. And ultimately led to legislation to try and deal with that issue because it was such a problematic situation during the truck weeks. That's correct.
And Mr. Carter, I have a feeling, and I may not, you reduce interactions between rowdy people and police officers, that's a good thing. I know in some jurisdictions, rentals are required to have people available, or they are available, so that they can step in like a hotel would and send up the night manager to tell those people in room 10 to stop partying so loud, stop drinking, or stop doing whatever they're doing. In these types of situations, under the sort of like the Dodge City rules that some folks would like to see, people do whatever they want, and then the regulatory entity becomes the police force. And it seems that the less that the police have to intercede, especially since they often involve alcohol, the better off it is for everybody concerned, because people come down, they're on vacation, they have a few drinks. And so that is, as I see it, is a part of not only the zoning violation, but that's one of these outgrowths that the city is looking at in terms of trying to reduce these difficult interactions.
Yeah.
So in your particular, I think it would be a subdivision. It's SFR 5. If you have a renter there and that person is creating a problem, you don't have control over it. And that's what Mr. Jackson, as I understand it, is speaking partially to. They have an infrastructure in place to deal with that kind of problem. And only when they can't deal with it do they end up having to call the police. And then the police have notice of that there is a problem and what's going on. And a lot of that is, I see it as at the root of why short-term rentals, and I had mentioned earlier, I don't know if you heard it, about the people who went to Disney and then they come back and then they light off fireworks at 3 in the morning. These are not appropriate things in a single-family neighborhood. And that's just basically common sense applying it to the different types of housing arrangements that exist in a community.
Yeah. Mr. Magistrate, if I may, we had hired a manager that is local, that lives in the neighborhood, and it is my understanding that that manager was readily available to go on site whether there were any problems. And that's why we hired that manager. But that being said, we fully understand what you're saying. Although we were screening the people that were wanting to rent, make sure that there was not going to be any problems. We understand the situation. We're just asking the clemency of the magistrate because we're new and we rented very few days and we complied immediately with the request of Mr. Yates.
Okay, all right. Mr. Carter, when we began, I began hearing these matters, I was routinely finding every violation to be the maximum of $15,000, which is the upper limit that is provided for by the irreparable and irreversible arguments made by the city. And I have pared that back continuously over the last few years. However, at some point, you are also, I know you may be living in Canada. You said you were from Canada, is that correct?
Yes.
But Florida law provides that you are on notice of what the city commission does. And furthermore, you're known, if he is doing this for business, that there are certain places that these are not allowed, which is virtually almost all of Daytona Beach, where short-term rentals are allowed. Am I correct on that?
Yes, it's the T district, is that correct?
There's a small zoning district.
Yes, just one.
But they're not very big.
Correct.
And so your manager should also, you're relying on him, but that's neither here nor there. That's the amount of $1,000 as we do other people. Other people have been in similar situations, less than the $15,000 that had initially been requested, and I have pared back, but I still feel that in your situation you did. So RTL 01-2505, I find the respondents Michelle J. and Daniel D. Carter to have been in noncompliance of Article 4 section violations are irreparable 62.091 and hereby order a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, that respond for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Thank you, sir.
Thank
you, sir.
We are part of a worldwide home exchange. Are part of a worldwide home exchange property, whereby there is no money leaving property, whereby there is no money leaving anybody. The bylaws of,
You're using a good or a service, so that is tantamount to money. It's the same thing.
it's the same
Now,
thing.
your friends can stay somewhere, but if you're exchanging anything.
It's the same
Now,
thing.
your friends can stay somewhere, but if you're exchanging any sort of good or service for it, then it is indeed a rental.
7 RTL 1-2506, MP Lake Forest LLC, site for failure to correct violations of Land Development Code Article 4, Section 4.1.A, Article 5, Section 5.2.A at 500 Jimmy Ann Drive, number 111.
State your name, please.
My name is Marissa Jenkins. I am the property manager of Lake.
2.8 at 500 Jimmy Ann Drive, number 111.
State your name, please.
My name is Marissa Jenkins. I am the property manager of Lake Forest.
You have permission by. My name is. Raise your right hand.
And
Zoning violation. The check-in, check-out time shows 4 p.m. and 10 a.m. These actions are irreparable and irreversible in nature, and the city is requesting, we would be requesting a fine of $15,000. However, we have a different request in error, and that the person was asked for a continuance to close the ad and to come back and then hear the case.
can I ask something of the inspector? Has there been
I would-
communication?
No,
Please.
that's indicate if there had been, I could have told them.
Property.
Yes, sir.
Okay. Short-term rentals frequently are overnights or a couple days stay or something, or overnights or a couple days stay or something like
To do a short-term
the property.
day when that happened.
Okay, and so we resolve this, and then you come back, and we work all of this out. But it's all the are worked out, and then I can hear that the matter has been hopefully sounds that your rules say you can't do this.
I am on your side. I don't want any short-term rentals on my property.
Okay.
None.
Yeah.
Okay.
None.
And Ms. Davis, I don't know, you are the renter at this point, so is that amenable to you that we continue this matter? Hopefully get a lot of these details worked out outside of discussing it here? Okay. And then Mr. Yates can come back and say, been done is undone, and the property is, as in most all of these others, is in compliance. And then I feel more comfortable, been done is undone, and the property is, as in most all of these others, is in compliance. And then I feel more comfortable dealing with the matter. Okay. So therefore, with the agreement of all concerned, case number 7, RTL 012506 MP, what would be the hearing date?
Next hearing date is.
Be the hearing date.
Next hearing is February the 25th, 2025.
This matter is continued to February 25th, 2025. And hopefully everybody comes back and we don't have all these loose ends that still need to, or it would be, but.
Yes, sir. Thank you.
Thank you.
Case number 8, RTL 012507, Portmore Construction LLC, site for violations of Land Development Code, Article 4, Section 4.1.a, Article 5, Section 5.2.8.2 at 921 Gardenia Drive.
Could you say
Andre Osborne.
ANDR?
ANDREOSBOURNE.
Raise your right hand. Do you solemnly swear or affirm what you're about to provide is the whole truth and nothing but the truth?
Yes, ma'am.
And your relationship to Portmore Construction?
One of the owners.
Okay. All right. Mr. Yates?
All right. The case before you was a zoning violation. This case was field generated. The pricing is of January 15th, 2025. The daily posted rate was $100 and it displayed 61 reviews. The check-in chime shows 3 p.m. to 10 p.m. and check-out 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $5,000.
Okay. Mr. Yates, can you repeat the day you first observed this?
November 8th.
Mr. Osborne, the determination that these property violations are irreparable or irreversible in nature.
Okay.
Is that something you need me to repeat? Or
No,
is
you
that,
don't need to repeat anything, sir.
So you waive up,
Yes, sir.
and that will be incorporated into the case, my prior.
Violation, these violations being irreparable and irreversible as set forth in case number RTL 012501 is hereby incorporated into, it's your turn.
Mr. Osborne. So as me after I got that thing property, they want him to show that where I live with my wife is an Airbnb.
And to be clear, you did take the ad down while we were on the phone and
No,
said,
I didn't take it down while I was
And
on the
said-
phone.
and
No.
Wait, you gotta allow him to.
Mr. Osborne is saying, just anything on Airbnb?
No, sir.
No.
At all.
He,
was on the
To do an Airbnb, sir. My partner's name. You
And
are
if-
telling I am
and-
doing, and I'm asking you to show me what I did wrong.
Could you go to the reviews, please? For instance, this one's, and if you see as the first review as evidence, you see that it says that it's attached to a restaurant. And then can you go to the Airbnb location that's shown on Airbnb? See, duplex apartment with restaurant attached. Keep going.
let's go back a moment.
Okay.
There's pictures.
Yeah. Okay, so that's the location of your restaurant, correct?
Yes.
And it does have a part.
It has one in a storeroom, and I live in there.
Okay.
And where would that be if I,
Go back. It shows you the corner of what roads it is. Sorry. It is Mason Ave. You can zoom in, guys, so you can see it a little better. We're 920. There it goes.
okay. Okay, so both the restaurant is 921?
I believe
It's
it's
posting, and
Is this,
on the right side. What you're seeing are Airbnb photos, and then on the left side are the interior photos from when he rented it. So you can see that they actually do match. It's the same. Keep going. And
so the
then
pictures that on Airbnb?
one side is Airbnb, one side is inside from a rental website of his home. can see that they match.
Which rental website is this on?
Posting. And I'll also testify that I have seen posting. And I'll also testify that I have seen when the area open to the back. I have seen the front when the area open to the back. I have seen the front door. It looks exactly the same. It's kind of hard to see from that photo.
But both the doors are the same.
Correct. Absolutely.
Everything is same.
Yes, 100%. I agree.
Yes.
And as stated, this is that location. This is those buildings. And has he agreed? Those are photos of his apartment?
Yes.
And so the city's, with the reviews and everything else, I feel the preponderance of the evidence, and it is my testimony that this is that address.
Okay.
And as I said, if you look at combative.
No. Assertive, that is, I may not be using the right, that is not your property. That is you. And I think maybe this one would be better to be continued, is to determine, is referring to?
No, sir.
Okay. Mr. Yates, do you have?
Please go to the, there it is.
No, I'm not the posting, but I'm talking about what's online.
The listing? Yeah.
The listing. You to do, I know.
Airbnb.
Okay.
It's around the same time as Zillow, I believe.
Okay.
Yeah, so no, it's a very old, very good website. And as he said, he's saying those are his photos he took. He's not disputing that.
Okay.
Okay.
They are.
I even moved in, sir. I designed that place myself. I left it here. So if it was posted, sir, I'm going to tell you what I think because I had to fire. If it was posted, sir, I'm going to tell you what I think because I had to fire somebody from my property. So if it was an Airbnb when I was not around, sir, I was not aware of that. Did I authorize anybody to do it? No, sir. Definitely did not.
Somebody posted it. And you're saying it, but it wasn't you.
No, sir. I'm saying it was never posted, like it was never rented where I received any money or know about it. But that picture, sir, is an old picture. That has to be an old picture from when both my places were empty. And those pictures were shot everywhere, sir. So anybody could have took that picture, but somebody actually coming there to do an Airbnb or something like that, I think that did not happen.
Somebody put those pictures of your property online.
And to be clear,
and there are 61 reviews. Do you have dates for those reviews?
Yes. Go ahead and move the reviews. Sir. And like I said, not only that, please, I mean, they're showing in September 2024, but not just that. If you also go to the next one, you'll see it says it is attached to a restaurant.
Well, I understand all that, but if I understand what Mr. Osborne is saying, he's not disputing that this stuff is out there.
No.
He didn't post it. That's if I'm correct.
Yes, sir.
Somebody had to post it. He may have. Do you have employees who work there?
Sir, what I have was a tenant in the back that I found out was doing some shady stuff. So when I'm not there, he was the guy in charge of the whole property.
Okay.
You understand, sir? So when I came in November, I didn't hear anything. I saw this paper on the gate and I called him immediately. So I were having some riff with the guy who I left with my place, sir.
We're making progress. Okay. We now have a potential party who may have posted these. Your tenant.
May, sir.
May have. I don't know.
He didn't admit to it. He didn't admit to it, so I can't put no blame on it. But to say my place had reviews and people coming in, I would have to see all that on cameras. I have cameras. I'd have to see somebody coming into my place. And it was shady, sir. I think that might be like a little scam thing there, sir. Not my place.
Yeah,
Mr. Jackson.
You know, Mr. Magistrate, I don't know about. What we do know is there's 2 units. He said he lives in one. I don't know about the second one, but presumably,
I have a lease for the second one.
You got to allow me to talk, sir.
Oh, but I can show you my evidence.
Okay, we got to still allow me to talk. We take turns. So the real question isn't whether or not this, even though he's adamant that it's not, if I can, even though he's adamant that it's not his property, it's clearly, and I think he ultimately acknowledged that it is his property. Now, whether it's him or it's his tenant or the other person that's, as he says, shady, that's there, we have.
He's no longer. As of
we
yesterday,
have
he's
advertising. You gotta allow me, sir. We have advertising that's clearly being advertised by everything that we see, 61 reviews and all the other circumstances that support an advertisement of a short-term rental on that property. And so I'm not sure what a continuance would resolve for us. As far as I have sworn testimony from the inspector that he spoke to someone who actually took it down. Now, whether this was this gentleman who says it absolutely wasn't him,
He never spoke to
or
nobody.
his tenant or partner, whatever the term they may choose to utilize, it was on this property. It was at this property, and it was ultimately resolved based on an actual conversation and involvement with the inspector. The inconsistency of the position of the respondent makes it even more questionable. The position that he is expressing of having zero knowledge. But in any case, what we do have is sworn testimony of the inspector, as well as evidence that contradicts some of the things that this adamant respondent has said. And so our position remains that he is in noncompliance, and we're asking for a fine. And I think he says he wants to present something to you, and we'll welcome him to present any evidence that he desires.
I just want to be clear. This gentleman is very adamant that he says he didn't post anything. Okay. And before we get, I want to be clear on, is there one unit or two units in the building?
Two.
And one of them was rented out?
Yes, sir.
Okay. You lived in another unit?
Yeah, I lived in the unit and also store my stuff for the restaurant in that unit.
In your unit?
Yes, sir.
Okay. And there's a second unit that has living quarters. It has bed, shower, bathroom, or whatever?
Yes, sir.
There's two.
And it was rented out?
Yeah.
Okay, so there's two units, one that you occupy.
Yes, and one in the back that's rented out.
And one that is rented out.
Yes, sir.
Okay. We're making progress because I was initially hearing that there was, under the impression there was one unit. I want to understand this. I don't want to make a decision based on on something other than facts.
Yes, sir.
Okay. You're in one unit. Your renter is in another unit.
Yes, sir.
Okay. All right. And with that, the pictures of the unit that Mr. Yates has shown, are those pictures of that rental unit?
Yes, sir.
Okay. And so you are suggesting, I believe, that your renter was subletting his unit.
No. No. No.
Well, how do you explain that there were 61 reviews of people who had stayed in that unit?
Because that didn't happen.
The 61 people just decided to make a posting on there?
Sir, I have no idea what to tell you about that. I'm not going to lie. There is no Airbnb at my property. And I would like for him to show me how I have it. He said there's inconsistencies in my story. My story has never changed. The guy, he was doing something. The police keep coming over there, sir. The police keep coming over there. He got some stuff going on. He was a manager of the property while I was out of town in Oregon for like 6 to 8 months.
6 to 8 months he had control of the property.
Yes, on and off. On and off. For the last 6 to 8 months of last year. On and off.
Okay, so, And so what I'm hearing is he could have posted it, and if he didn't tell you, you wouldn't know, would he? Is that what
No,
that be?
that's not what I'm saying. I'm saying I have no knowledge of the Airbnb being up at all. But the only person at all who could have access to that, to my facility, would have to be him. And I don't see that. I don't see nobody renting it out with all my restaurant stuff packed up in there. So I don't know what's going on there. Just like I said to him, like, I don't know if that's a scam or what's going on. I don't have an Airbnb property. I have nobody managing an Airbnb property. I'm not having an income off an Airbnb property. That's where my wife is. That's where my wife stays. Me and my wife, we stay there.
But you said you were out of the area for 6 to 8 months.
Yes.
And was your wife with you?
Yes.
Okay. So and your renter, though, was here during that time, correct?
Yes. With control of the property on and off for 6 to 8 months, which is this year, 2024. My bad. 2024.
Okay.
So that would be the only time anybody would have access to my place. So if you're saying that's in that time frame or without, the only time frame I could give where I can't 100% give accountability for my property would be the last 6 to 8 months or 2024.
Is that the period that
And I came back in November.
Okay. But is that the time period that we're talking about these reviews have been posted, Mr.
I
Yates?
don't have the totality of them. I generally capture the newest reviews.
Well, I see September 2024. 4 years ago. Oh, 4 years. July of 2024.
That's how long she's been on Airbnb. She stayed a few nights in July. I just want to enter one more thing in. We make case notes, and I entered this case note on January 15th, 2025. This gentleman called me. I spoke with the owner. He disagrees about our ability to site his property and said he's not running an Airbnb, but removed the ad at my request.
You're lying.
And I'm just
So
telling
do we
you
have
what
that
my notes
recorded?
show.
Do we have that recorded? Because it was a recorded conversation.
Unfortunately, it was not.
Okay. Yeah, but I was talking and then he talked. So the loss does only go to me?
No.
Because I was talking and he talked.
Inform you
Okay.
how this is going to, if you continue to cause a disturbance, I want you to leave.
I'm not causing
I
a
need you to
disturbance.
Listen to
I
the
was
protocols,
talking to sir
and
and he
directly to the
spoke.
magistrate.
Well, you could tell him the same thing too.
Talk directly to the magistrate. Thank you.
Okay. Mr. Jackson, I have a question for you.
Yes.
Assuming that Mr. Osborne's renter had control of the property. I'm not saying he did, but just assume that. And he was posting these ads on Trulia. Who would be responsible ultimately if the city was bringing a violation?
Mr. Straight, Portmore Construction LLC is responsible regardless of who was that property.
Is that because they're that
They're
owner of
they're
the property?
owner.
Okay.
They were responsible to who was at their property, what was being done at their property, and they did to remedy it. Ultimately, it was January 15th. Whether because Mr. Osborne or anyone else that was doing it on his behalf or contrary to his knowledge, it's his corporation, it's his LLC, it's his property, and he would be responsible. The idea that it was on for months or half a year or 3/4 of a year, and he had no idea, that's a duty of an owner to have an idea what's going on in the property that they own. Especially when it results in 61 reviews.
Okay. Mr. Yates, do you have anything further?
At this point, I think we'd just like to ask for a determination.
Okay. I am struck by the fact that the posting is admitted by all concerned that this is this property. Okay, and there are 61 reviews and that the owner was away from this property, but as I take it from Mr. Jackson's statements, the owner is ultimately, or Portmore Construction is ultimately responsible for what goes on there. And based on what I see, and the fact that when the city asked for the reviews to be taken down, or the posting to be taken down, it got taken down.
Sir, could I say something?
Yes, you can.
He's lying, sir.
Well,
he's lying.
I'm looking at the posting, which certainly appears to be real. The pictures, which have been stated are the inside of the premises. And
Well, sir, I have some questions that it seems like I'm already going down the road. Cool. Those pictures, those one right there, that's the moment my place got finished. That's the moment my place got finished.
When was it finished?
That was like 3-4 years ago.
But that was the moment it got and the review seemed to be over the last several years. So
how you know that, sir? You are assuming that. He just told you he can't tell how long the reviews are there. And you want to
well,
say
I
it's
see some of the reviews dates on them.
There? Yeah, so which one got any date recent, sir? Please.
That's from last year, September.
Yeah, September 2024.
September 2024. And
July, June.
Okay.
I'm living there.
Well, you said you were away for a year.
You said September of that's 2024. My 24. Bad. I'm thinking about 2025. So, yeah, I don't have an Airbnb.
Sir, you may very well have been the victim of your tenant who placed this online, but that's ultimately, it is the owner of the property who is under Florida law responsible.
By law.
By law.
So no matter what happened there, if I'm present or not, it falls on me, on my part?
Yes.
Even without knowledge of it?
Mm-hmm.
That is crazy.
Okay, so
I guess my another question is, I heard him ask for $5,000. I heard everybody else asking $4,000.
I'm going to reduce it to $2,500 because of the number of reviews and the situation. But I have run into this before where it appears that there are straw men who appear, and at this point, given the number of violations and the fact that this has, and so the difference between being notified on the 8th of December and the 15th.
What? The
Mr.
8th of when?
The 8th of November, and yeah.
8th of November.
No, sir.
That was when the posting was
Which
placed.
posting? Sir, I got
Violation
paper.
was posted.
Yeah, it was violation. I have a timestamp photo of it. Yes, sir.
And that was 8th of November?
Yes.
And it was resolved on, taken down on the 15th of this
January.
year?
Yes, sir, 2025.
January. Okay, so I think I've heard all I need to hear at this point. And therefore, in case number 8, RTL 012507, I find the respondent, Portmore Construction, LLC, to have been in non-compliance of Article 4, Section 4.1.a, and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals. Such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 500 Jimmy Ann Drive, oh, I'm
Look.
sorry, at the property at 921 Gardenia Drive, and to subsequently come into compliance on January 15th, 2025, and hereby order that respondent shall pay a fine in the amount of $2,500 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Oh, it's done? Sir, no chance I could pay 2,000 because I really don't have it like that, sir.
It becomes a
for real.
lien against your property. And Mr.
But, you know,
Jackson
it's
can
kinda,
probably
I
speak
just
to
gotta
that.
say, sir, it's kind of unfair the way you guys,
No, I was
guys-
going to ask if
you-
we could take a brief recess, but I'll wait till you all finish. I just needed to.
Yes, sir. I just want to say one thing. The way you guys basically do your investigation in these things is kind of, I would say, a little bit too. You're not going in depth in it. So staying on the surface or just the internet. Anybody could put anything on the internet. You guys are not aware of that. But yet still, there was nobody who came there physically to come in the apartment or anything like that. to see
Sir,
what was going
I'm
on.
taking your statements that you were not present, okay? So you can't testify as to whether or not there is somebody present or not.
Yes, I have camera.
Mr. Austin, your case is over, sir.
Thank you, sir.
Yeah.
Thank you.
Can we take a brief recess?
Okay, it being 11:06, and we'll take a 10-minute recess and reconvene at 11:16. 5-1, and in the of miscellaneous business. Okay.
I need to swear her in. State your name, please.
Sarah Kirk.
Do you solemnly swear the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay. This is case number 1, RTL 012510, BMS Holdings, LLC, cited for failure to correct violations of Article 9 Holdings, LLC, cited for failure to correct violations of Article 9, Section 9.2.a at 543 Division Street.
With the city, my credentials are on file. This case is brought before you as a repeat. This case is brought before you as a repeat offender. The property at 543 Division was previously cited for being in violation of trash and debris and being an unsecured and unsanitary structure, with the first notification back on 12/1 of 23. The property was previously found in noncompliance by the Code Board on 5/9/24 in order to come into compliance by 7/3/24. That would be case CEB 04-2469. Compliance was achieved on 7/3/24. After that date, on 10/2/24, I observed the property to be back in non-compliance with the above referenced violations. I re-inspected the property on 11/6/24, 11/21/24, 12/4/24, January 2/25, January 8/25, January 15th, 25, January 21st, 25, and then again this morning, I observed the same violations again. That's January 20th of 2025. That makes a total of 9 occurrences. This morning, there was actually somebody, 2 individuals inside the bottom to the left. If you zoom in right there, you'll be able to see somebody. You can zoom in. Right there, yep. There's somebody hanging out there, okay.
What is the violation there?
Unsecured, unsanitary. The violation itself from the IPMC.
If you could, I think your pictures start in December.
The first one is actually October 2nd of 24.
If you could just go through and just briefly state
Sure.
what it is that the picture is showing that's a violation.
Okay, so it's unsecure, trash and debris. If you could zoom in, I think most of the front door is open right there.
That's still not being secure.
Correct.
Okay.
Yep. Okay, and then the next picture, I believe, is also October 2nd. If you could zoom in, that's showing trash and debris.
Okay.
Okay. And then next picture, that is November 6th. Obviously, trash and debris, and you can see the windows are open upstairs.
Is this property occupied?
No, sir.
Are
It's a
people
vacant,
are people living in there? I mean, the windows are open. It would suggest that maybe people are.
Okay, well, I was going to get to that. I do have a list from the Daytona Beach Police Department showing calls for service of this location, going back to 5/9/24 when they were first found in non-compliance. So a lot of the calls are trespassers with arrest. Open door, they've had to clear the property multiple times. There's a total of 15 calls for service for this month.
Is the water turned off and electricity turned off
Yes.
at that property?
Okay. So, so there was, do you want to continue going through the pictures? So this is November 6th. If you can see, the upstairs window and lower window is broken out where they've gained entry. So people are using the property as, miscellaneous police issues in the neighborhood. It's causing a major nuisance to the neighborhood. There's a side window right there open. That's November 6th. Drugs, prostitution, stuff like that's going on. It's definitely a nuisance for the street and the neighborhood. Okay, so a total of, we'll go on. November 21st, you got trash and debris, unsecured. It's still unsecured, windows open. This is December 4th. Windows open upstairs. window downstairs, trash debris. And now we've got a plastic bag over a window, probably securing, or, so nobody can see in whatever's going on there. And that's January 2nd. January 2nd, again, you can see the door knob has been removed and the door is ajar. This is January 8th. If you zoom into that lower left window right there, you can see the door is ajar and the window's open. And January 15th, where I posted, again, door is ajar, window open. And that's January 21st, door is open, window open. This is January 28th, so this is morning. And you can see the door is open right there. And this is, I actually saw 2 people inside of the, sorry about the quality picture, but there's a couple people hanging out inside.
Is that a person
Yes,
by
sir.
that window?
Uh-huh.
Okay. And there should be anybody in there?
No. So it's just a vague property that they're not maintaining. They're not checking on it. They're not, they're just allowing it to be run with.
Okay.
Mr. Magistrate, if I can just say for the record, the prior violation finding of the amended order of noncompliance that was entered June 17, 2024, in case number CEB 042468, the conclusion of law said that the findings of fact constitutes violations of the Land Development Code, Article 9, Section 9.2A, which references the International Property Maintenance Code, and the codes that were violated was 301.3, 304.3, 308.1. 301.3 of the National Property Maintenance Code says vacant structures and land, vacant structures and premises thereof, or vacant land shall be maintained in a clean, safe, secure, and sanitary condition as provided herein, so as not to cause blighting problem of adversarial, not to cause a blighting problem or adversely affect the public health or safety. So that's what 301.3 says. 304.3 is specifically reference to having proper numbers on the outside, I believe. Look for certain here. 304.3 premises identification would cite it there. I don't believe that's one of the things
They did correct that. That one remained corrected.
saying was repeated. And then 308.1 is rubbish.
Yes. Rubbish and debris.
So 308.1 is accumulation of rubbish or garbage, exterior property and premises, and the interior of every structure shall be free from any accumulation of rubbish or garbage. So those are the prior violations. The position of the staff is that those are being repeated, and pursuant to 162.06, those repeat violations are what's being brought before you, and pursuant to 09, that would be up to $5,000 per occurrence for each time that they've been repeated.
Okay. Those items that you cited come out of Article 9, Section 9.2A?
Yes. That Article 9, Section 9.28 adopts the International Property Maintenance Code as well as the Florida Building Code.
Okay.
And these are International Property Maintenance Code violations that were cited then and being recognized again, repeated.
They were in non-compliance, and now they are continuing non-compliance.
Right. They were previously found in non-compliance. They ultimately brought it into compliance, and now they're back in non-compliance again.
Okay.
And if that occurs within a 5-year time period, that would be a repeat violation pursuant to the definitions in the statute.
Okay. And so what is the city is asking for a fine to be imposed as a repeat violation?
Okay. So, let's see. The staff is requesting a maximum of $5,000 per occurrence with 9 occurrences totaling a $45,000 fine.
And if I can state, I believe you're saying that because the impact of the blight that it's causing on the community and the health and safety concerns, including the necessity for law enforcement involvement on this property.
Yes. Yep.
Okay. Any further?
I brought an extra copy of the calls for service in Daytona Beach to the Daytona Beach Police Department, showing trespassers, arrests, people on property that were moved along. They had to clear the property multiple times. I've had multiple complaints from neighbors regarding the property, so that's why staff is recommending the maximum of the $5,000.
Any communication to or from the landowner himself?
No communication.
They have not responded, but they've been notified.
They have been notified, and they have not responded since they came into compliance back on July 3rd of 2024.
Okay.
I have nothing further.
You said you have documents. I'd like to look at them and have them entered in as exhibits. Okay. Okay, these are yes, these are call logs with different dates and different items that were, well, reflect, do these reflect items that you saw or were
Those
aware
police
of?
calls. Police.
Police, okay, this is police.
Yep, they are calls for service to the Daytona Beach Police Department.
Okay. We have various items that are, to some extent, you said the doors were open.
Right.
And okay, windows unsecured, doors open, trespassers. I'd like this entered in as Exhibit A in this matter. And how did you get that list? Was that provided to you from the police department?
Yes, it was provided by the Daytona Beach Police Department.
Okay.
By request.
Is there anything else that you had that you wanted to, that you were referring to, like an exhibit type paper or anything?
Nope, that was
Okay.
it.
All right. Ms. Jackson, do you have anything?
No, Mr. Ridgeo, nothing for.
Okay. Then case number 1, RLO 12510, once again in of sections of Article 9, Section 9.2.A of the Land Development Code.
Yes, as to what I said, 301.3.
Okay.
Being unsecured property, I believe that's the all of the photos were referencing specifically that as the violation, as well as point 1, which would be the external and internal conditions.
And as I said, left off on Article 9, so 9 relating to the nature of the building and the open windows and doors, and through 8.1, external and internal conditions such as the trash and rubbish that was observed on the property. Anything?
Nope, that was it.
Okay. And this all being at 543 Division Street. And respondent shall.
I'm sorry, I didn't know if you specifically said that you were finding it as repeat violation.
Did not.
I did not? Okay. And that this is a repeat violation. And hereby order the respondent shall pay a fine in the amount of $5,000. Was this going to be per diem fine?
No, it would be per occurrence.
One time?
No, we're asking for a per occurrence fine. So
Oh.
for each time it occurred.
Okay,
It's
pay a
what
fine
our-
in the
what's
amount of
noticed.
$5,000 per occurrence. and not violate that section of the land development code again. And that for any future repeat violation, respondent may be placed on a subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $5,000 for each occurrence as per Chapter 162 Florida statutes. Is there anything further you like?
No, I believe I
Included?
It's the magistrate.
Okay.
I'm sorry? Say that again, say that. There were 9 occurrences? Oh, I didn't hear what he said.
Okay, so there were 9 total occurrences. Those were the, that corresponded with the photo evidence I provided.
So we're asking for
A total-
$5,000 fine per occurrence?
Totaling $45,000.
Okay. I'm going to have to redo this from
Yes, I'm sorry.
9 occurrences.
Trying to find things that would help you.
Okay.
On my case.
I find okay, in case number 1, RTL 012510, BMS Holdings LLC, I find the respondent, BMS Holdings LLC, to have been in non-compliance of Article 9, Section 9.2.A, for property at 543 Vision Street. The non-compliant, there were non-compliances relating to Florida Building Code violations of Section 301.3 and 308.1. Did I say 9, by the way? I think I said 9
Yes, you did.
violations. For the and hereby order that respondent shall pay a fine in the amount of $45,000. That'd be 9 times 5.
And that this is a repeat violation.
Hmm?
And that this is a repeat violation.
And that this is a repeat violation. And furthermore, that the respondent shall not violate the section of the these sections of the Land Development Code again, and that for any future repeat violations, the respondent may place on subsequent for hearing before the magistrate for consideration fine of up to $5,000 for each occurrence as per Chapter 162 Florida statutes.
Yeah. Sarah, just to make sure we have the correct dates. We have a violation on 11/16. We have a violation on 11/21. We have a violation 12/4.
I'm sorry, start over.
11/16. Well,
No.
go ahead and get to me.
Okay, the first one would be 10/2/24. The next one, 11/6/24. 11/21/24. 12/4/24. 1/2/25. 1/8/25. 1/15/25. 1/21/25. And 1/28/25. Okay.
Okay?
Thank you.
Thank you. All right, we'll return to where we left off. Mr. Yates. Next case is going to be number 9, RTL 012508, Julian Paola Borges Rodriguez, cite for direct violations of Land Development Code, Section 4.1A, Article 5, Section 5.2.A.2 at 2426 Tulane Avenue. You want to swear in the witness?
Could you state your name, please?
Julie Borges.
And raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay. Ms. Borges, these violations relate to the property being used for what is known as other accommodations which are not a permitted use in the zoning district. Mr. Yates?
Yeah, the case before you is a zoning violation. This case was field generated. The property is zoned MFR 40. Other accommodations known as short-term rentals are not permitted in the zoning district. The violation was first observed November 13th, 2024, and they were notified this.
Tony didn't address her to see if she did him to repeat the city's argument.
one?
I haven't done my.
I don't do that until after he finishes.
Oh, okay. Sorry. I'm sorry.
No worries. The violation was first observed November 13th, 2004, and they were notified the same day. The property stopped actively advertising as of November 14th, 2024. The daily posted rate was $65. The advertisement displayed 2 reviews. The quiet hours ranged from 11 p.m. to 7 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, requesting a one-time fine of $1,000.
Mr. Jackson, do you want to say? Mr. Yates, you have anything further to say?
No, sir.
Mr. Jackson?
Ms. Rodriguez? Yes. I'm Anthony Jackson. I'm an attorney for the city. I've previously, I don't know if you've been here the whole time, but I've previously expressed to the magistrate the city's position related to our request that these violations are deemed irreparable and irreversible in nature, which is a provision that's provided for in Chapter 162 of the Florida statute. So from that presentation, I make that, or our intent is to do that in every case. And so I can do that presentation again if you hadn't heard it. No, if you did hear it, and if you are willing to waive me doing it again, then you can just advise the magistrate of that and we'll move on.
No, we can move.
Okay. So.
Okay.
The first that I wanted to say is sorry because I didn't know the law. I did before same day I have tenants for November 1st, and they have a year contract. I bring all the contracts just to, if you want to see it. I just call when the tenant give me the violation. I just call the inspector. I said, sorry, apologize to that. I sent an email with the proof of the new contract, with the proof, the C of the that I and the contract need to get the D, the college, and everything for kids, and everything of the same because I don't wanna do anything that is not right.
Okay. So the posting is down?
Yes, immediately. She shut it down. I have it by the next day, but she's saying it may very well have been that day.
Okay. And we have it.
Yes, was immediately because I called you right away. Because the tenant just gave me the violation. I called him and I said, sorry, I forgot because I have contracts November 1st with Jocelyn. She's living there. And here, if you want to see, it's saying I just print it out in just case you want to see it.
No, you
Immediately, absolutely.
And said he's asking for a fine in the amount of $1,000, which is typical of these situations. You have some reviews, so it hasn't rent out.
The reviews should be for another property they have in Orlando, but if you want to forgive me the penalty, I will shave. No, I pay because I know.
Circumstances, the fine Mr. Yates has stated is $1,000, so that's what I will be doing. Therefore, in case number 9, RTLO 12508, of Article 4, Section 4, irreparable and irreversible improper benefit obtained by the owner in a damaged surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 2426 Tulane Avenue, and who have subsequently come into compliance on November 14th, 2020. Respondent may be placed on a sub-agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Okay, thank you.
Okay, case number 10, RTLO 12509, Noah Dovberg is cited for failure to correct violations of Land Development Code Article 4, Section 4.1.a, Section 5.2.8.2 at 834-836 North Oleander Avenue.
Could you state your name, please?
I know Dovberg.
Raise your right hand. Do you?
Yates.
The case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in the zoning district. The violation was first observed December 12th, 2024. They were notified the same day. The property stopped actively advertising that same day, December 12th, 2000.
Okay. Mr. Dovberg? Oh, Mr. Jackson.
Mr. Dovberg. Yes, heard this numerous times. You happen to be the last one up.
Yes, sir.
As I've expressed before, I've given the city's position regarding irreparable or reversible. I'll present that to the magistrate. Is that something you need me to repeat?
You do not need to repeat. I understand.
Jackson's repetition statements or his presentation regarding these violations be irreparable and irreversible in case number 2, RTL 125.1. And as I stated before, Mr. Dovberg, you take exception.
Good morning, Honor, Mr. Yates, Mr. Hall. My name is Noah Dovberg, and I reside at 836 Norlander Avenue. Some of you may remember me from a few years back. I was testifying before the code enforcement and Mr. Sensen for my father, who had many violations on the residence notice and helps contribute to violate low codes. Lack of knowledge is no excuse, and I do understand. The magistrate was very kind to allow me to help my father a few years back, which I have the utmost respect for. My paychecks from this job into this house, working tirelessly to build a future for myself at this address, where I was first showed up in a blanket fresh out of the Halifax hospital in 2000. This was an income idea that I thought would assist me in funding this huge home improvement path I'm on. I did not think to look into local zoning codes and blindly jumped into it, which was a mistake, and I do understand that. It was a very short-lived idea, and I ceased operations within about an hour of Mr. Yates notifying me, and only ran the operation for a short time and hosted about a handful of guests. It does not lessen the fact that I still violated local codes, taken very seriously due to the safety and privacy concerns of the neighborhood, and I apologize for my negligence. I'm before you to ask for the magistrate, Mr. Yates' forgiveness with this issue in an attempt to remedy my mistake. I do understand the severity of the matter and will no longer host a short-term rental at this property. I am politely asking for a reduction to the fine, Your Honor, whatever seems necessary, being that I complied very quickly. Thank you for your time.
And I can back up the time frame he's stating for compliance.
Okay. Does the city have anything that they wish to provide in response to what Mr. Dovberg has stated?
No, nothing. And I also will confirm that, yes, the property, we have seen marked change in the property since he is taking it over, and it does look much better.
Thank you, sir.
We're willing to reduce it to $750. I mean, that's our recommendation instead of the full $1,000. I do recall Mr. Dovberg coming in on behalf of his father, and I recall his father for all of the years.
Yes, sir.
He's been here since 99.
I apologize.
No. The house looks great.
But yeah, I think we're willing to at least recognize that he did do a lot of, at least at the time, I know he was working real hard. I don't know how it looks now. I didn't notice the picture.
It's not a code violation, that's for sure.
Well, very good. That's our position.
Well, Mr. Dovberg, you've gotten a reduction.
Thank you, sir. Thank you, Your Honor.
So I will now read in the order and we'll make it official. In case number 10, RTLO 12509, I find the respondent Noah Dovberg to have been in noncompliance of Article 4, Section 4.1a, and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.09(1)D Florida statutes for the property at 834-836 North Oleander Avenue, and to have subsequently come into compliance on December 12th, 2024. Could I say a few hours after being notified?
Yes.
And by order that respondent shall pay a fine in amount of $750 and not violate that section of the development again, and if any future violation respondent may be placed on subsequent agenda for hearing by the special magistrate for consideration fine of up to $15,000 for each occurrence per chapter 162 Florida statutes.
Thank you, Your Honor. Thank you,
Thank
Mr.
you.
Thank you, Mr. Dixon. Thank you all.
Keep it good work, man.
All right. We have one last item, miscellaneous business, RTL 102362, 582 Revival Boulevard. Respondents, in this case, being Malini and Aaron Karam Tandani. Site for failure violations, land development, Article 4, Section 4.1a, Article 5, Section 5.2.8.2, which were relate to short-term rentals. And there is a or fine. It was a fine and finding and fine imposed on October 24, 2023 in the fixed amount of $15,000. There was a lien review in January 2024, which was denied. So at this time, there was initially an amount due $15,000 plus $24 in recourse fees, but the respondent has made payments in the amount of $9,000 since February 2023, and the total amount remaining on the lien is $6,024. This is miscellaneous business, but I really see this as more of a lien review where there is a lien on the property and the respondents are asking for a reduction of some amount of that lien.
Yeah, Mr. Magistrate, the only reason we didn't indicate it as a lien review is because it's had a prior lien review. And as indicated, it was denied. That was in January of 2024. And so we don't really have a practice of doing over and over again lien reviews until we finally say yes. But so from that perspective is why we didn't see it appropriately going on as a lien review. But we did want to allow the respondent to be heard, and so that you can consider whatever she's asking. We have a thought on how we would resolve it internally, which I believe she has a need for some delay, and we would be willing to grant some delay in her payment period. But I would, but again, we're willing for her to be heard. We don't believe that based on our practices that we would truly be eligible for lien review at this stage. I mean, you made the ruling. She's been making the payments. It's at a state of we fear opening the door to everyone coming after they do a partial payment and say, okay, will you consider me again for an opportunity to reduce this when you've considered what's been considered in previously?
You raise a very good point. And that's something that, I think we need to consider, is that generally when somebody is found in violation, there is a fine imposed. And at that point, their recourse is to go to circuit court. That's called an appeal. I'm not real keen on reconsidering things unless there is some incredibly new evidence that warrants reopening something that that should have been considered and for some reason was not. I don't know if there's not a third category. It'd be nice if there was. I think we'll call it miscellaneous. Really not. A couple of years ago, and if I understand the petition, that it goes to essentially the ability to pay the amount, not the fine were made. Those have been heard. The time period for filing an appeal has lapsed. So that's water under the bridge. It's old history.
And what we don't want to do is rehash. I mean, what was denied before. Willing to do. We've discussed this is to allow this respondent, from an administrative perspective, as you typically give them notification that if they don't be timely especially if in a lien review situation, but even in this situation, the lien belongs to the city, and the city can make whatever types of adjustments it elects to a certain extent, and this can tell her additional time we have a problem with. And if she wants to take a gap period, it elects to a certain extent, and this can tell her additional time we have a problem with. And if she wants to take a gap period, speaking with the supervisor, and this can tell her additional time we have a problem with. And if she wants to take a gap period, speaking with the supervisor of a 3 or 4 month gap period in her payment taken on herself a payment plan. I don't know if it was, I'm thinking her payment taken on herself a payment plan. I don't know if it was, I don't think it was mandated, but she had a payment plan and she has been paying in good faith. There's no complaint about that. And so my best.
Okay, well, what I'm looking at, and maybe it's sort of coming to me now, is that we're talking about, to me now is that we're talking about extraordinary circumstances. And extraordinary circumstances. Ms. Karam circumstances. And Ms. Karamchani and says that there is a hurricane involved, which is an extraordinary circumstance. Okay, that sort of opens the door. That sort of opens the door. I want an extraordinary stance. I don't want something to come back that, the cat ate my homework. On an extraordinary stance. I don't want something to come back that, the cat ate my homework. That's not an extraordinary circumstance, but hurricane is. And my understanding is the argument is premised upon a hurricane. That there are payment issues on that. And so maybe that's where I'm going with this, is that if we have something or whatever, but an extraordinary circumstance that gives rise to the need to reconsider something that's old history. Yeah. And so I'm just trying to carve that out just so we don't end hearing things over and over again because, everybody would like to. We don't end hearing things over and over again because, but it's something
for us. And so what we have a quasi-judicial proceeding, typically not stop addressing if they so like. We just don't make a formal portion of the process because we don't have a process that other than dumping back in the jury. So understanding, and I don't know if that was before we shared, typically not stop addressing if they so like. We just don't make a formal portion of the process because we don't have a process that other than dumping back in the jury. So alternative ready or not, but my understanding that she needed to come back to address that correct, staff. So that's the reason why.
Okay. I have just recall years ago there was a period where matters that seemed to never if you feel that the decision, and I think that at some point we have to say enough's extraordinary, or it's something that the city feels very strongly about, or something of that. I see as something that warrants rehashing it. It's extraordinary, or it's something that the city feels very strongly about, or something of that nature, so that that people keep. So that we don't have 47 additional items on the agenda, all of which have been decided before, so that that people keep. So that we don't have 47 additional items on the agenda, all of which have been decided before, and are simply coming back and get a better deal.
On this, however, we do leave open from the perspective of the magistrate. That's our position, that it's open, it's over. But we do leave open if the magistrate from Ms. Don't know her last name. Magistrate from Ms.
Karen Chandani.
The respondent. If the magistrate so elect to hear from her, we don't have a problem with you hearing from her. Our position would remain, though, we do believe we can aid her in the manner in which she sought assistance through an administrative remedy that would come from our code team, and it's not necessary that we necessarily have a ruling of any type.
Okay. Well, why do we do this,
Riggio, I also want to point out that she has been paying, and so we have not added interest to her lien. She's continued paying, so we've never added the interest.
Well, I noted that, and I mean, we are dealing right now with someone who's made $9,000 in payments, which is a significant amount. And so,
so we appreciate and respect that, and that's why we have the administrative interest in trying to help her finish accomplishing her responsibility.
Well, again, it goes back to my point. It's not every day a hurricane hits your house, and so So I would like to hear from her.
Okay, could you raise your name, please?
Nalini Karamchandani.
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Please go ahead and state
Thank you. So basically, I was in compliance and was paying and gratefully paying it on the date, but the last Hurricane 24 paid the house rentable to my current renter. And if I have the balance waived, because it was my intent to pay the whole thing off, but it was not foreseeable that I would have the damage incurred by the hurricane that would not be covered by my insurance.
Okay. Mr. Jackson?
Our
I know
position
you-
remains understanding that in her circumstance.
Okay. But I'm hearing two different, asking for the remaining amount to be waived. And you were talking earlier, as I understood it, about some kind of,
It's suspending the monthly payments. She doesn't have to continue on a monthly, a certain time period.
yeah,
You know, the option is to leave the rest there and never pay it and let it accumulate as a lien. Make the we see it willing to say, oh, well, I understand it's turned down and just didn't extend anymore. The repairs and the necessity things that would need to be done, we understand that. We're not insensitive to that. And so we would allow her to take care of that. She can have that added income to be able to remedy this without the impact of additional fines or additional encumbrance on property. When I say additional fines, I mean interest.
so there would,
Fines, I mean interest.
so there would be, would the city be willing to consider, I assume from what you're saying that you are not in favor or
That's
waiving. Would you consider a time period in which there would be no interest or other administrative fees assessed?
If forwarded, then
If I'm correct in this, there's a limited amount of money and you're pouring that into making the repairs in the house.
Correct.
If you went that route, what would you feel is an appropriate time period whereby you would not need to make any, you see what the city is proposing, a period in which the amount would remain at $6,004 until such time as you were able to accumulate enough money to begin making, to start paying that off.
See, I wanted to pay it off in a timely manner, so I was trying to make a large amount, which would be $1,000 a month. If they would allow me to make $250 a month, then I would make $250 a month till the $6 is paid, without any additional penalties or interest or service charges.
all right. So what's being suggested? Okay, I think we can do a little better. So 3 months, 4 months. I said which one? 3 months. Okay, we can 3 month leave. No payments at all. We'll be okay with that. And then after that, if she wants to zoom only 250 as opposed to 1,000, world consistent. And only thing changes, it stops. We probably go
She
ahead
was
and,
talking about $250 a month some time periods.
well, I think let's talk about 250 months until it's paid off. And she, okay, and okay with us. But we'll give her that gap period where she would not have to make any payments so that she can at least get herself caught up.
We're in February, March. Resume payments in what, April or May?
Whatever.
February, March, April. I think it would be like May 1.
Okay,
May
yeah,
1st.
let's call it May 1. What I hate, I guess that's the caution I started with, Mr. Riddle. I don't know if she, okay,
May
yeah,
1st.
let's call it May 1. What I hate, I guess that's the caution. She really wants to be bound by an order on the payment. The payment is,
I personally that you all feel is because ultimately these fines, unless they are these liens, unless they are released, remain operative forever or
until we take
it seems
action
like.
or 20 years.
Somebody sells it or whatever, and so this sort of like a really boo in her.
Right, and we almost have you here as a mediator in this regard, and what we'd actually do is just go ahead and acknowledge by letter, and as she knows, or come back and become it in the presence of the magistrate. I'm sure he would be interested in trying to see what else he can do. But our intent, and I would ask for the staff to go ahead and follow up with a letter acknowledging, will allow you this extra time period, hold interest, and not proceed with adding interest to the payment, and allow you to continue making the payments at a lesser amount. As long as it's a steady payoff, that's fine with us. So that's
All
our
right,
position.
I appreciate that. Thank you.
So would that be $250 a month starting on May 1st?
Yes. Starting in May, whenever
In May.
you get the money in May to make the May payment. And I think you've been in contact with the staff. So, y'all just stay in contact and know what.
Resolve your problem?
Yes, thank you.
Okay. Thank you.
That's everything.
I don't think there's anything I need to do.
Thank you. I think that's everything.
Well, we have a new rental technician, Lena, so we should announce that
Where's Lena?
to Mr. Riggio. This is the new rental technician.
Okay.
Which means that's the new June? Is that what we're saying? So that's the new June. That's the new toe.
okay.
Like I said, you have new toe with Melissa. So we got it.
I don't know about that, but I'll work on it.
And likewise, we're not throwing her in the next month, but whenever she's ready, she's ready. We're ready to roll.
Well, she's getting a lot of experience from these last couple sessions.
It's very good.
Things come out of the blue.
And we have a new blower.
With new blowers.
Yes, we met.
Oh, yeah, we have a new blower too, as well.
Yes.
Oh, where you are, back there.
Very good.
Much prettier.
Okay. Well, it's good.
Sergeant Conley. That's who we have back there.
Sergeant Conley.
Who's slowly
Okay.
becoming one of my favorite people. Not slowly, quickly becoming one of my favorite people.
That's even better.
It's good meeting you. And my only word of advice is on a lot of this stuff, the more eyes that are on it and review it, the more likely we don't have to come back and revisit things later on when somebody missed a date or a amount or something. And, so we keep things moving smoothly and we don't have to revisit old matters. That's keeps these meetings a whole lot shorter. So that's it. Are we ready for adjournment?
We are.
We're ready.
It being 12:18, I hereby call this session of the Special Magistrate proceeding to be adjourned.